We simply cannot allow people to pour into the United States undetected, undocumented, unchecked.
And complete the dang fence.
This bill that we will sign today is not a revolutionary bill.
Cast down your bucket where you are.
We come from France.
And I am, adamantly against illegal immigrants.
They're coming in by the thousands, just unbelievable.
A wall is an immorality.
Who are you rooting for?
Those masters of the universe are at it again.
You maniac! You blew it up!
Welcome to Parsing Immigration Policy, the podcast of the Center for Immigration Studies. I'm Jessica Vaughan, Director of Policy Studies, subbing for Mark Krikorian. And my guest today is my colleague, George Fishman, who's a Senior Legal Fellow at the Center. And he has written and followed extensively the topic that we're going to be discussing today, which is the Alien Enemies Act that is at the center of the controversy over the Trump administration's removal of about 300 Venezuelan and Salvadoran gang members, many who were removed to El Salvador, to the infamous detention center there. And so we're going to discuss the Alien Enemies Act and the strategy of the Trump administration and how this has been received by the first court that it landed in and by the public. So welcome, George.
Well, Jessica, it's a pleasure to be on with you.
All right, thanks. So can you first of all explain to our listeners what is the Alien Enemies Act and how is the Trump administration deploying this in this situation?
Well, first, I should say that contrary to rumors, I was not a congressional staffer when the Alien Enemies Act was enacted in 1798. So I just wanted to
Are you sure about
get that on record.
Because I think I was working for the center then.
This was during the French Revolution, and there were widespread fears in the United States, the new country of the United States, that we were going to be invaded by revolutionary France. And the Alien Enemies Act was one of the infamous Alien and Sedition Acts of that time. However, the Alien Enemies Act was the only one that had widespread bipartisan support. Vociferous opponents of the Alien and Sedition Acts, such as Thomas Jefferson, James Madison, were fully supportive of the Alien Enemies Act, and it has been pretty much, with only a few tiny modifications, in the law in that form for well over 200 years. It's been used in World War I, World War II, the War of 1812, and it essentially provides when there is a declared war between the U.S. and a foreign nation or government, or invasion or predatory incursion by such nation or government on U.S. territory, all nationals, all natives who are over 14 or older of that nation may be designated by the president as alien enemies, and they shall be subject to summary detention and removal. The law has been upheld as constitutional for well over 200 years, all the way up to the Supreme Court on multiple occasions. Courts have recognized it grants an extraordinary amount of discretion to the president in its use during wartime. And, there are statutory requirements, but once those statutory requirements are met, the president can essentially decide who to detain, who to remove within the class of nationals of that nationals of that enemy nation who have not become naturalized U.S. citizens. It's always been used in the context of a traditional declared war, military engagements between nations, but that doesn't necessarily mean that its novel use by the Trump administration is any less legitimate. The law provides an invasion or a predatory incursion by a foreign nation or government. So the two tests the administration will have to meet in using the Alien Enemies Act against members of terrorist organizations, criminal cartels, such as with Venezuela, are, is it the act of a foreign nation or government? And can it be considered a predatory incursion or invasion of the United States, since there is no declared war? And I think, this is going to have to be decided by the Supreme Court, but I think an excellent argument can be made in the appropriate situation where the facts back it up, that if in these so-called mafia states where there's such an interconnection between the government of a nation and organized crime, criminal cartel, terrorist organization, that the act of that terrorist organization, criminal cartel, can be legitimately attributed to the act of that nation, then it's perfectly legitimate to utilize the Alien Enemies Act. And President Trump has done that with Venezuela. He has tied the government of Venezuela to TDA.
Tren de Aragua.
Yeah, President Trump set forth in his proclamation the case that it is, in fact, so intertwined with the government of Venezuela. I believe he called it a hybrid state, a hybrid nation, that use of the Alien Enemies Act would be legitimate.
Yeah, this is interesting to me because I've been following the discovery and spread of TDA in the United States and know a bit about how it got established here, what they were doing. It was a prison gang in Venezuela that there was an escape a number of years back. And for years, the gang was doing human trafficking, drug trafficking, and human smuggling of Venezuelans to other South American countries, especially Colombia and Peru. And so they were in the trafficking business for a while after they got out of prison. But this is not the same as a street gang. This is a gang that was formed in prison. These people were already criminals in Venezuela and were prosecuted and convicted and incarcerated in Venezuela long before they ever came here. So it's not like they got here and a bunch of Venezuelans got together and formed a street gang at all. This was organized crime before. But I was interested to understand this link between the gang and Venezuela. And have you seen anything more on those links articulating that relationship, or is this something that's yet to be fully talked about in public?
I'm certainly not an expert in that area. All I can do is, focus on what President Trump said, that Nicolas Maduro, who claims to act as Venezuela's president, maintains close
and not
ties
recognized by us.
Yeah, maintains close ties to regime-sponsored narco-terrorists. He leads the regime-sponsored enterprise Cartel de los Soles, which coordinates with and relies on TDA and other organizations to carry out its objective of using illegal narcotics as a weapon to flood the United States. In 2020, Maduro and other regime members were charged with narco-terrorism and other crimes in connection with this plot against America. Over the years, Venezuelan national and local authorities have ceded ever greater control over their territories to transnational criminal organizations, including TDA. The result is a hybrid criminal state that is perpetrating an invasion of and predatory incursion into the United States. Those are the words of President Trump.
Mm-hmm. And yeah, so this is really not as much of a stretch as some implied, that just because we don't have military troops fighting Venezuela and Venezuela itself has not invaded the United States territory, but that there is a relationship and criminal intent behind some of the actions of the Venezuelan government, that, it's essentially a narco state.
Well, this will have to be decided by the Supreme Court. I think when in 2023, I first wrote about this issue and tried to make the case that the Alien Enemies Act could be used in cases involving mafia states where they're intertwined with transnational criminal organizations. I thought an excellent case could be made, but it would be, a case never considered before in the courts, because as I mentioned in the past, it's always been used in cases of traditional wars, War of 1812, First World War, Second World War. And, it's a novel use. And, those are the statutory terms. We'll have to see. I have, though, been pleasantly surprised in the litigation over the deportation of Venezuelan gang members, TDA members, under the Alien Enemies Act over the last few weeks or last month. While the federal district court in D.C. has temporarily restrained further deportations, that stay of deportation has been upheld by the D.C. Circuit. In both cases, the district court and the D.C. Circuit were not dismissive of the argument that this is the legitimate use of the Alien Enemies Act. In fact, both the district court and the circuit, broached the argument that this was a inherently presidential determination that there was this mafia state connecting the Maduro regime with TDA, not to be challenged by the court. That if that was the president, they didn't make this decision, but they certainly talked about it in the sense that this very well could be one of the cases where the courts need to defer to the judgment of the president, who under the Constitution is in charge of this country's foreign policy. Now, there still are, even in that case where the court, if the court decides it's not going to need to be convinced on its own of this connection, but if the court defers to the president, there's still the issue of whether aliens to be deported have the right to hearings. And certainly in past uses of the Alien Enemies Act, even during World War II, the courts, the Supreme Court, have been clear that while the president has a great amount of discretion, the statutory prerequisites still have to be met. So if an alien about to be deported, for instance, in World War II as a German national, claims, wait a second, I'm not a German national, I'm a naturalized U.S. citizen, I'm a national of France, and therefore the Alien Enemies Act doesn't apply to me, that is something that a court would need to consider and decide. And, that was done frequently in World War I and World War II. So, based on prior precedent, there's still certain issues which need to be litigated, but the president has extraordinary discretion.
Well, I think that's a really important point, that the concept itself does not seem to be at issue here in the court cases. But before we move on to the things that are an issue in these court cases, I want you to explain how the procedures of removal would be different, or if you can even call it removal, under the Alien Enemies Act from, let's call it, regular immigration law, in other words, Title VIII. This is a question that I've been getting a lot from reporters and other observers is, why does the president feel that he needs to use this? What's wrong with, immigration law? How is this working differently?
Well, Jessica, as you know, there are so many things wrong with immigration law. For the same reason that during the COVID pandemic, Presidents Trump and Biden relied on Title 42, that there is simply no feasible way under standard Title VIII immigration procedures to keep out of the country or remove large numbers of aliens. Ordinary procedures. There's a backlog of 3.7 million cases in immigration court. There are a few hundred immigration judges and 3.7 million cases. It would be simply impossible to expeditiously remove large numbers of aliens who are a danger to the United States under those procedures. Even if it wasn't for the backlog, their deportation cases under Title VIII are all appealable to federal court.
And there's no specific ineligibility or inadmissibility or ground of removability for being a gang member, correct?
When I was a congressional staffer, my bosses long advocated for a ground of deportability for violent transnational gang members, and it's never been enacted. So you're exactly right. Merely being a member of a dangerous, vicious, destructive, transnational criminal gang is not a ground of deportability. You're exactly right. And so under summary removals, under the Alien Enemies Act, there is no need to go through immigration court. You bypass that 3.7 million backlog. There's no need to show a ground of deportability, such as, a specific crime that an alien has been convicted of. It's the president's power to summarily deport and remove pretty much immediately with a few provisos. The most important being, if an alien challenges that they're a member of the class of alien enemies, that's a legitimate matter for the court to determine. In World War II, was this person actually a German national? In this context, in Venezuela, is the alien actually a member of PDA? And interestingly, that sort of is a self-imposed requirement by President Trump. Under the Alien Enemies Act, he could have designated every Venezuelan national who was not a naturalized U.S. citizen in the United States as an alien enemy. He decided to limit the use of his power to aliens who are not legal permanent residents, but who are members of PDA. He didn't need to do that. If he were to simply make the class every Venezuelan national, the only matter a court would be able to consider is this person a Venezuelan national or not? That would be the only matter really to consider. So, in effect, this would allow for the quick, expeditious, almost unappealable summary detention and removal of aliens in times of war, including war perpetrated by mafia states using terrorist organizations, using organized crime, using criminal cartels as, elements of their government.
Speaking of expeditious, some have said, well, why can't the president use expedited removal, the accelerated form of due process that applies in certain situations, specifically those who can't show that they have been here longer than 2 years. And, so that's not necessarily available in the case of all these individuals, correct?
Yeah. Expedited removal enacted in 1996 is unfortunately fundamentally broken, as are many of our immigration laws. It's broken because if an alien, even if they're subject to expedited removal, claims a fear of return and goes before an asylum officer, and the asylum officer says, yeah, you have a credible fear of persecution, then expedited removal is over. They're sent into that 3.7 million backlog of immigration cases. So expedited removal ceases to become expedited. Now, that was okay in the beginning when few people knew about how to abuse expedited removal. But now it's well known throughout the world and propagated by smuggling organizations. And they're not, contrary to the Biden administration's contentions, the smuggling organizations, the smugglers were not being deceitful. They were not lying. It's true. 80-90% of the people in expedited removal who claim a fear of return, asylum officers say, yeah, you have a credible fear in 80 to 90% of the cases. So everyone knows if they're apprehended at the border and put into expedited removal, just claim a fear of return, and that ends expedited removal in its tracks. Now, typically in the past, expedited removal could only be used aliens who have been in the U.S. for no more than 2 weeks and hadn't gotten more than 100 miles past the border. But Congress, in the expedited removal statute, allows it to be used, as you indicated, for aliens who have been in the U.S. for 2 years or less, who were not admitted, were in the United States, came here illegally, were in the U.S. 2 years or less. So that it theoretically could be used against many of the Venezuelan gang members, most of whom came in under the Biden administration because of the Biden administration's policies. And maybe half of them, have been here for less than 2 years and could be subject to expedited removal, except for two things. One is it's not clear whether the use of expedited removal against aliens who have been here for a year or two is constitutional. That's up in the air. But even if it was, again, all they would have to do was say, I fear return to Venezuela, and, the wheels off the cart. They would just be thrown into the 3.7 million backlog. Maybe, a decade later, they'd get before an immigration judge.
Right. And on top of it, many of them were granted parole or temporary protected status as well, which adds more layers of complication to removing them.
You're exactly right. And while President Trump has sought to revoke, to terminate President Biden's abuses of his statutory powers under temporary protected status and parole, the courts are now coming in and halting, at least temporarily, President Trump's ability to do that. So it may be years before we get a definitive ruling from the Supreme Court on President Trump's termination of those abusive grants of parole by the Biden administration. So yeah, you're exactly right.
And just as an aside, recently a judge in California ruled that DHS Secretary Noem's order to terminate TPS for some of the Venezuelans who had it most recently, it cannot be implemented at this point, basically arguing that no one else has ever tried to terminate TPS before, and describing some of the Venezuelans as gang members is racist. And so these are some of the reasons why the administration has been blocked. Yes, Judge Chen in California.
Just incredible. And, it's sort of just incredible and abusive for a federal judge and to do something like that. And I hope it gets overturned on appeal. It's sort of like deja vu all over again. I served at DHS for the second half of President Trump's first term. And yeah, there were abusive decisions by federal judges all the time, halting President Trump's immigration initiatives. And there just wasn't enough time to appeal to get them all overturned before the end of the 4 years of President Trump's first term.
So it's not hard to understand that given all of these hurdles and obstacles to prompt removal of dangerous gang members who arrived illegally in many cases or were given some kind of protection under the Biden administration, you can see why the Trump administration would be frustrated with just trying to solve this using existing authorities under Title VIII immigration law, and that this, extraordinary problems require extraordinary solutions. Although this one, was provided by Congress for the president in extraordinary situations. So I want to get to this one particular issue that's coming up with these particular cases that the courts are looking at very closely, that you've already mentioned, and that is how the government is establishing that these particular individuals qualify for expulsion or exclusion or removal under the Alien Enemies Act. And that is, how exactly are they determining that they are gang members? I suppose it's not so difficult to establish their country of citizenship, but tell us a little bit about this complaint raised by the advocates against use of the Alien Enemies Act in this case.
Sure. In defense of the courts and in defense of the D.C. courts, just as a German national who was to be summarily detained or removed during World War II, per the Supreme Court, had a right to go to court to demonstrate that they were not a German national. If the class of enemy aliens is Venezuelan members of TDA, then under that same line of argument, an alien would have a right to go to federal court to say, wait a second, I'm not a member of TDA. Let me demonstrate that I'm not a member of TDA. And so I do not begrudge the courts their role, in determining whether an alien is a member of TDA, as long as the class of aliens is members of TDA, just of enemy aliens is members of TDA. Just again, as in World War II, if the class is German nationals, then the issue is an individual a German national. As I indicated, the president, in my mind, could get around that problem by simply declaring all Venezuelan nationals enemy nationals, and therefore there would be no need to demonstrate in court that a particular alien was a member of TDA. But my understanding, the contention is yeah, advocates, the ACLU, et cetera, have long argued, that, just because an alien is covered head to toe in gang tattoos, that doesn't mean they're a member of the gang. They're just a fan of the gang, or this was a soccer tattoo or something of that nature. So a lot of the arguments have been about things like that. One of the problems the government has is that, especially with an antagonistic, oppressive government like Venezuela, they're not going to give us information about criminal histories in Venezuela of nationals, gang members who have come to the United States.
Right.
I think these advocates, their goal in mind is saying, unless there's this definitive proof, from a court that someone is a gang member, it can't be used against them, knowing that it's extremely difficult to demonstrate this level of proof, especially nationals of countries that refuse to give us information from their criminal justice systems. So, it's a difficult issue, but, again, in my mind, one that could be avoided if the government were simply to expand the class of enemy aliens to all Venezuelan nationals.
Mm-hmm. Well, I have to disagree with you a little bit on how difficult it is to establish gang affiliation or association. I mean, I understand what you're saying, and I understand why the ACLU is raising this point, but in reality, these criticisms that, the administration is doing this on the basis of just a tattoo or flashing gang signs or because somebody, was talking to another gang member, that's really an oversimplification of how the government actually goes about designating gang members and all law enforcement agencies, not just the federal government. There is a pretty well-established set of protocols that law enforcement agencies use to designate individuals as gang members, and it's much more sophisticated than just tattoos or what they wear. It has to do with whether or not they've been convicted of a gang crime, if the government can show that there are close associations, and a lot of this is potentially a problem for the government to release publicly because it's law enforcement sensitive and may compromise informants. Often they're making these determinations based on surveillance or the contents of an individual's telephone or social media account. There are all sorts of other things in play here. And tattoos, especially with the case of TDA, they're really not that known for having a lot of tattoos, unlike MS-13. Their tattoos tend to be mainly for leadership or longtime members. But the ACLU has released one of the documents that the feds are using called the Alien Enemy Validation Guide. And it goes into great detail and shows how these designations are made. And it's very clear that you have to have much more than a tattoo and the right color shirt to be designated a gang member. And it can never be just because of what they call symbolism associated with the gang. It always has more to do with criminal conduct, relationships, and things that they have done and said rather than these external kind of associations with gangs. So I think that's important for people to point out. I'm pretty confident saying that while there may have been mistakes made in some of these removals specifically to El Salvador, the government is going to a lot of trouble to not make frivolous designations of people as members of TDA or MS-13. And I think rightfully so, given all the scrutiny that has come on on these removals. So this idea that it's tattoos is a myth.
I certainly defer to you to that, Jessica. You're, probably CIS's premier expert in that area. Is it your view that in a lot of instances, if the government was forced to provide all this information in court in every case in which an alien contests there being a member of the TDA for purposes of the Alien Enemies Act, that a lot of sensitive information would have to be released?
It's possible. I think it's actually a good thing that this alien enemy validation guide has been released so people can read it and see what the government is going through to establish this. But, I think there are potential problems if the government is forced to do that in every individual case, what their evidence was on specific gang members. I don't know if we'll ever get to that point, but I can see how this would be a problem. And I'm wondering if, the fact that they're using the Alien Enemies Act and, that this is by definition inherently national security related, if that would give them some cover for the courts.
Well, I mean, that's certainly, the argument that the Trump administration is making, and we'll have to see how the Supreme Court eventually rules. But, the issue here is, the statute itself provides, these are statutory requirements for the use of the Alien Enemies Act and, put in place by Congress itself. And, not just put in place by Congress, but put in place by Congress shortly after the signing, the Constitution was accepted by the states. So, in my mind, at least, the easiest way to get around this conundrum would be for the president to simply designate all Venezuelan nationals as subject to the Alien Enemies Act. And, and then in my mind, at least, there wouldn't be a statutory requirement, to show that an individual is a member of TDA or to demonstrate to the court that an individual is a member. But, these will all be things that we will have to see how the Supreme Court rules. Yeah.
So one thing I want to ask you is, what do you think is the proper role of the courts in this situation? What should they be looking at? Do you think it was overreach to block this nationally? You've said that it's going to go to the Supreme Court. I'm sure that's true. I'm kind of interested in whether you think the court has a legitimate role here and where this is going to go.
I mean, I certainly think the court do have a legitimate role. And, I certainly think that when federal courts issue orders, they need to be abided by the administration until those orders are overturned by a higher court. I think, again, there are areas where the president has almost complete discretion, who to utilize the Alien Enemies Act against in terms of who to detain, who to remove. But just in terms of how it's been used before in, World War I, World War II, how the Supreme Court has interpreted it, the two primary issues, if there's a challenge, the Supreme Court has, determined are legitimate to be considered by the court are, has there been a declared war? Has there been a predatory incursion or an invasion by a foreign nation or government? That's the one big one. The other big one is, if there has been, is a particular alien actually an enemy national? Are they a member? Are they a national of the country which has been determined to be an enemy nation? And so, definitely the administration is arguing that even these issues should be simply matters for the president to decide under his constitutional powers of foreign policy. And that's ultimately what the Supreme Court is going to have to grapple with and decide. I'm certain this is, sooner or later it's going to get up to the Supreme Court.
Okay. Well, our listeners are going to have to stay tuned to find out how this ends, I guess. We're certainly going to be following it as it proceeds and any other developments on this issue. Thank you so much, George, for taking the time to talk about this with us. I know I learned a lot, and I appreciate your staying on top of this and your ability to clarify what's going on.
Jessica, it was a pleasure to be on with you. I myself have learned a lot in this podcast, and I'm sure it's something we will all be very attentively following.
I appreciate that. Thank you. In the remaining minutes of the podcast, I wanted to also discuss another interesting development in immigration enforcement in the state of Florida. As of the end of February, we now have every single one of the 67 county jails and other correctional centers in Florida have signed an agreement with ICE to implement 287G agreements. These are partnerships for delegation of authority that are available to state and local law enforcement agencies to essentially be deputized to enforce immigration laws under the supervision of ICE. And these programs have been around since about 2002, when Florida was one of the first states to participate. But until now, we have not had an entire state and all of the principal law enforcement agencies working within that state get this authority to enforce immigration laws in cooperation with ICE. It's really a new development. All of the county jails are doing this now, and they have begun their training. And it's not just the county jails that will have the ability to identify and process illegal aliens who've been arrested for state and local laws. In addition, the Florida Department of Law Enforcement, which is the statewide law enforcement agency, the State Fish and Wildlife Commission, the Florida State Guard, the Florida Highway Patrol, and even the Florida Department of Agriculture's law enforcement agency are going to have 287G authority going forward. This will allow these officers to question individuals about their immigration status and even detain and process them for removal if appropriate. They will be able to stop illegal aliens arriving in Florida by sea. They will be able to transport illegal aliens to ICE. And so this is really a significant development. It's not only going to be a force multiplier for ICE and really one of the only ways that ICE is going to be able to meet its goals of really significantly increasing immigration enforcement, but most importantly, it is, in addition to just finding criminal aliens who are arrested in Florida, it's going to allow the state to address specific crime problems that are associated with illegal immigration, like drug trafficking, gangs, human trafficking, identity theft, illegal employment. All of these problems are something that the state is going to be able to address following their strategy or trying to achieve their goals in law enforcement. They won't just be an extension of ICE and ICE's priorities. And this is going to reduce the criminal alien population in Florida. It's going to deter illegal settlement. And it's going to reduce the size of the illegal population in Florida. It's a great model for other states to follow, and I hope other states will pick up on this. There is currently a bill in Texas that is being considered by the legislature that would mandate 287G programs for all the law enforcement agencies in Texas, but reportedly has some high-level opposition there, and it's not clear what the chances of this legislation are. But I hope they will look to Florida for an example of how this can be implemented. Plenty of other states could do this as well. So we're going to have to stay tuned and watch what happens in the state legislative season to see which other states want to sign up to assist in the Trump administration's immigration enforcement agenda and really make a dent in this problem that we've seen grow over the last 4 years. With that, I'm going to sign off from this episode of Parsing Immigration Policy. I hope you enjoyed this episode. I hope you'll check out other episodes on our website that you may have missed. With that, I want to thank you for listening.